is the UCC federal or state law? Is the UCC federal or state law? Matt? Is the UCC federal or state law? Ah, very good. And therefore, when I was going to law school in Georgia, and I'm curious, how many of you have your textbooks with you today? So look at the, do you have the UCC in the back, an appendix in the back of the textbook?
Yes.
Okay. And I think there are something like 700 articles in the UCC. And when I was going to law school in Georgia, we studied the UCC. We also studied the Georgia variations of the UCC, and there were about, of the 700 articles, there were about 12 of the articles that were different. So would you say then, Brandon, that the regular UCC and the Georgia Code are pretty much the same, that there's only 12 of the articles that are different?
Yeah.
Now, why was it in the Georgia Law School did we study both? What do you think? Well, we might want to practice law in Georgia, so we need to know the Georgia rules. But we might want to practice law outside of Georgia, so we need to know the UCC rules. Plus, we want to pass the bar exam. Now, do you think, Brandon, that I should teach you in this class the Missouri variants to this UCC?
No.
Why not? That's correct. Why not?
Because they're both probably pretty similar.
And also, the CPA exam tests the UCC and not the Missouri or the Kentucky or the California variants. Does that make sense?
Yeah.
Plus, there are not that many variants to begin with. Okay. So, Cindy, you came to ask me a question yesterday about the United Nations Convention for Contracts for the International Sale of Goods. And Michael, there's another name for that. What is that? That is a treaty. That is an international treaty. And it's an interesting question about, and there's a very interesting case law about when treaties override domestic law and when they don't. But Cindy, you brought a question to my attention. You quoted something from the textbook. Do you know that page number? And also, I'm curious if you have the same page numbers I do. So Michael, chapter 20 begins on page, in my book.
374.
Oh, okay, so they kept the same page numbers. Cindy, can you direct me to the page you asked me about?
No.
Oh, Kelsey?
If I saw it, I could get it there.
And as she's looking it up, Brandon, let's talk about another issue. The World Court is based in Hague, and in the 1980s, you might remember from history books that there was a revolution in Nicaragua, and the ruling party were the Sandinistas, and we supported the Contras, who were doing a guerrilla war against them. And the government in Nicaragua, that's hard to say, well, that country down in Central America, sued the United States government in the World Court and said that the United States government was in violation of international law. What do you think the court said? Well, Kobe, what do you think the court said? Speak to Angela. Do you think that the court agreed that the U.S. was in violation of international law?
No.
Yes, they did. And now, what do you think, Taylor, was the American reaction to that? Was the American reaction well, sorry? Or was the American reaction, you had no jurisdiction over us?
No jurisdiction.
Speed forward 20 years, and the United States sues China because China did not enforce copyright laws, allegedly did not turn a blind eye to copyright violations, went to the same court. Who do you think won that case, Taylor? The Americans or the Chinese?
Chinese.
The Americans won that case. And then, what was the reaction of the Chinese government? We have no jurisdiction over us. And the Americans said, that proves that China is a lawless country with no respect for law. Now, my point is not to make a political point or to take sides in the political issues, but my point is that, what's my point, Michael? that depends on what side of the issue. If you win a court case, there's justice. If you lose a court case, the judge is on the take. So, show me where this is.
It's underlined.
It's underlined. Oh, I should have looked at that. So if you have your book with me, turn to page 393. And look at the part that's underlined. 393 on the right-hand column, the last paragraph, or the last sentence of the paragraph on the right-hand column, where it says, whenever a choice of law is not specified in contract. You see that? The Hague Convention indicates the law of the country where the seller's place of residence is located will govern. Now, help me interpret this, Michael, in line with the point I just made about the World Court. Does that say that that's the law? If I was an American dealing with somebody from France, and that suggests that I would be governed by French law, am I bound by that? And would an American court be bound by that? If we wanted to be, but not if we didn't want to be. So it doesn't say, Michael, that this is the rule. It says this is a position that the Hague would take. Just like, Michael, the World Court took the position that the United States was wrong in the 1980s and right in 2001, but it didn't matter either way.
So you'd have to put in the contract where you want the law.
Well, but the question is, and that's a good point. If I was dealing with somebody from Malaysia, would I want to put in the contract that we would follow American law? Yes, I would. The Malaysian is going to want to follow Malaysian law. And then how it gets put in the contract depends on who's got the best negotiating ability. Does that make sense? But what if we forget? Then it depends on, I think the Malaysian court would say, hey, we got jurisdiction. And the American court would say, hey, no. That makes sense? Now, one of the questions that I will post today that will be due next week has a question about the CISG. But let me read you what Becker says about that question. To the depth tested by the examiners, the CISG is the same as the UCC. And rather than that's the same as the Missouri Code and UCC is substantially the same. And in fact, the truth is this is modeled after the UCC with minor variations. But to the extent tested by the examiners, the CISG is the same as the UCC. Mention of this convention is an attempt by the examiners at distraction. Follow that? So in other words, although Sydney, technically it's not accurate to say they're the same, just like Brandon, it's not accurate to say that the Georgia law and the Missouri law are the same. For our purposes, they are. Does that make, for the purposes of CPA exam, because the objective here, Michael, is not to prepare you to practice law, in which you would need to know Missouri law, but to get you ready for the CPA exam. That makes sense. Also, the first online homework was due last night. Let me repeat what I said at the beginning of class. Several years ago, when I started teaching legal environment for the first time, I debated about whether to use the online homework or not. So I went to Professor Smith, and he says, well, frankly, I don't like it, but I use it anyway because it gets the students to read the textbook. Did it? And that's a good outcome. Then I asked Bob Kane, who was my student worker at the time, and he said, frankly, I don't like it, but it encourages students to work together. Did it? Say yes. And Angela, make sure that there was a unanimous chorus of yes when I asked that question. Make sure you edit the tape. And I think getting students to read the textbook and getting students to work together, Brandon is a good thing. Okay, Ms. Sherwood? So let's start with the CPA questions. And see what we have. Some interesting questions here. So question number 1, which is Candace and Matthew. Candace, I apologize because this one is too easy. But you need some easy questions sometime. What's the answer?
D.
D, as in dog? By definition, this is the classic creditor-beneficiary contract. Matthew, you agree?
Yes.
Question number 2, Kobe and Kelsey. Graham contracted with the city of Harris to train and employ high school dropouts residing in Harris. Graham breached the contract. Long, a resident of Harris and a high school dropout. So Kobe, the person that were, the category of people we're trying to help, although not mentioned by name, sued for breach of contract. So under circumstances along with, Kobe, let's look at A. When, because Long is a third-party beneficiary entitled to enforce the contract. Or B, when, because the intent of the contract was to either to confer a benefit on all high school dropouts residing in Harris. Kobe, it seems like to me that A and B say exactly the same thing in different language. Is that right?
Yeah.
A and B say exactly the same thing in different language. And Kelsey, one of the things I said that I want to develop by going through the CPA exam is a technique of reasoning exam. So I think, Kobe, anytime you see two answers that say the same thing, they're wrong. That makes sense? So we can eliminate A and B. Somebody agree that A and B say the same thing in different words? C, lose because Long is merely an incidental beneficiary. Or D, lose because Harris did not assign the contract rights to Long. But Kelsey, I've already eliminated A and B. Which one can I also eliminate?
D.
D, because that doesn't even make sense. Now, so Kobe, the answer has to be
C.
C. Well, let me think about it. Kelsey, why is he not a third-party beneficiary?
It's not mentioned by name.
He's not mentioned by name in the contract because this benefits a group of people and he's in that group, but he's not mentioned by name. If, Kobe, you agree, Kobe? Kobe, if he were mentioned by name, then he would be a third-party beneficiary. But he's not mentioned by name, he's in the class of intended beneficiaries, therefore he will lose, therefore the answer is C. But notice again, Kelsey, I couldn't reason through that answer simply by the process of elimination. Question number 3, Alex and Taylor. Jones owns an insurance. Let me ask you a simple question before I even read the question. Alex, can I buy a life insurance contract and pay the premiums on the lives of my grandchildren? Can I do that? In fact, is that common for grandparents to do that or parents to do that for children? Is that common? So, Taylor, you agree that I can do that? So therefore, Jones and this speaks volumes about insurance companies. They're willing to take the premiums, but they don't want to pay. So Jones owns an insurance policy on her life on which she paid all the premiums. Smith was named the beneficiary. Jones died, and the insurance company refused to pay the insurance proceeds to Smith. The action by Smith against the insurance company for the insurance proceeds will be, let's start at the bottom and work here. Taylor, unsuccessful because Smith did not pay any of the premiums. That doesn't make sense. Unsuccessful because Smith was not the owner of the policy. That doesn't make sense. So therefore, Alex is either A or B, which makes more sense. Successful, A, because Smith is the third party donee beneficiary, or B, successful because Smith is a proper assignee. A. You agree?
Yes.
That's okay. Question number 4. Jody and Greg. February 1st, Burns contracted in writing with Nagel to sell Nagel used car. So let me see if I can diagram this. So here is West and Nagel. They have a contract, and West is going to give a car, and E promises to pay. So it's in accounts receivable. Have I got the facts right, Jody? Yes?
No,
No? Okay, tell me what's wrong.
you're doing fine, except using the.
Oh, I'm sorry, B contracted with Nagel, okay. B contracted with Nagel, and then B did what?
And then, he assigned his.
B assigned the rights to, or sold the rights
Sold it.
to E. Now, put yourself in N's position. If you're in, Greg, if you're in, how do you know who you should pay?
You should be told.
Ah, so therefore, for this to be an effective assignment, N has to receive notification. You agree? Jody, you agree? You don't agree? Tell me why.
Well, as long as Burns knows, if N pays B, then B should be able to give it to him.
But that's not the provision. The provision is, B is not promises to pay E the money. B is selling E the accounts receivable.
Yeah.
So therefore, B is not saying, once I get the money, I will pay you. B is saying that B is saying that N will pay you. So, is notification necessary? Because if you're in, who do you know how to pay? Now that I've done that, Jody, what's the correct answer? Greg?
D.
B?
D.
Well, let's see about this. By making the assignment, Burns explicitly warned Nagel would pay the full purchase price. Is there any promise to that? So I think A is wrong. Let's put B aside for the moment. Will also be subject to any contractual defense that Nagel would have raised against Burns. Well, that's not true, because when you step in somebody's place, you assume their rule. By making an assignment, Burns is impliedly warranted. And what does the implied warrant mean? Well, what's a warrant mean? Warrant means a promise. So an express warrant is one where I state it. So an implied warrant is where I don't state it, but it's implied. So by making the assignment, Burns impliedly warranted a lack of knowledge of any fact impairing the value of the assignment. Maybe. But I think the best answer is B, because it has to be noticed for it to be effective. Question 5. This is David and Bijou. Weston Barton entered into a contract. After recording valuable consideration of Egan, West assigned the rights under the Barton contract to Egan. In which of the following circumstances would West not be liable? So let me think about this. If West released Barton, what do you think? David? Don't think so. If West breached the contract? Don't think so. D, if Barton paid West, and originally I thought the answer was D. That's what I thought, but then I misread the question, and so let's read the question carefully. Notice it says, after receiving valuable consideration. Therefore, David is that part of the contract. So therefore, E, to say the answer is D, is to be redundant. So that's not the right answer. So, Bijou is the right answer, C. If Egan released Barton. Yes. David, you're good. Now, question number 6 actually could not be handled by the material that we went over last time, so I picked this question on purpose so that we can get some experience at reasoning where we don't know the answer and we reason through. So, I'm sorry. David and Bijou, you were doing, this is your question. You were not doing fine. So Sydney and Katie, you can do 6. So Sydney, tell me what's the purpose of the statute of limitations?
How long you can press charges against?
Okay, so therefore, you and I have a contract, and we have a contract for me to provide services to you, and I'm negligent in providing the services, and 20 years later you sue me. What's the problem?
It's been 20 years.
It's been 20 years, what's the evidence, the memories, the witnesses all dead, etc., etc., etc. So therefore, usually statute of limitations in the contract case is 3 years. So the statute of limitations are, consider this. What if you are a shoplifter and you shoplift at the age of 18? Should you be looking over your shoulder for the next 80 years to be arrested for that? So it gives you some, so then I know the purpose of the statute of limitations. David, number A, which of the following statements is correct regarding the effect of the expiration of the statute of limitations? Once the period of the statute of limitation is expired, David, the contract is void. No, we still have a contract. You just can't enforce it. You just can't sue me anymore. But we still have a contract. So A is wrong. David, the expiration of the period of the statute of limitation extinguishes the contract's underlying obligation. Sidney, think about this. This is kind of like the earlier point about Kobe. Do A and B say exactly the same thing in different words? Alex, you agree? Once the period of the statute of limitation expired, the contract is void. Well, expiration of the period of the statute of limitation extinguishes the contract's underlying obligations. And as a general rule of thumb, Sidney, when you see two answers that say the same thing in different words, they're both wrong. Plus, it's inconsistent with the underlying concept. So then, David, a cause of action barred by the statute of limitation may not be revived. Let me think about that one. Yes, suppose, and later, David, we'll talk about this when we talk about debtor-creditor law. Yes, suppose that I loan you money, and the statute of limitations on a debt, on collection of a date, is 1 year since the last payment. Got the story? Candace, you got the story? I loaned David money. I don't know why. Moment of weakness. I loaned David money. Statute of limitations to collect 1 year after the last payment. He's not paid me in 15 months. Candace, can I sue? He's not paid me in 15 months. Statute of limitation runs a year from the last payment. He's not paid me in 15 months. Can I sue him? Statute of limitations runs from the last payment date. So, 15 months later, he cannot sue me. Everybody, Megan, you agree? But then, Megan, what if on the 16th month, he makes a payment? Now, a cause of action barred by the statute of limitations may not be revived. Megan, when he made me the payment in the 16th month, that revived the statute of limitations.
No.
It didn't? What do you think, Taylor? I think it did because now, so let's suppose the statute runs out in July, he makes me a payment in August, that means the statute now starts running from the last payment, which is now in August. So again, Megan, has that revived the statute of limitations? So it's expired, but David, your payment, and thank you very much, your payment starts the statute again. So David, C cannot be correct. So therefore, I think D should be correct. Sidney, the running of the statute of limitations bars access to judicial remedies. And I think, David, that's what she said at the very beginning of this discussion. Therefore, Bijou, the answer is D. And, David, even though we're not discussing the statute of limitations, because, David, it's not possible to discuss everything, we were able to reason through that. So now, somebody was complaining to me, I won't mention their name, Kelsey, that Kelsey, this person was in my legal environment class, and the person said, well, I'm bored in this class because we haven't done anything new. So now, unnamed person, Kelsey, we will now do something new. Article Title 2 of the UCC only applies to the sale of goods which are defined as tangible and movable. So my question is, the UCC applies to a good. A good is defined as tangible and movable. So tell me whether UCC Cambridge would apply to the sale of a house.
No.
Why not? It's tangible. I can touch it, I can see it, I can feel it, but I can't. I don't know about that. Have you ever seen a house moving down the highway? You can move it, but it's not easily movable. So the answer is no. What about Megan, an employment contract?
No.
No. What about Michael, the sale of a computer?
Sure.
Sure. What about the sale of a new car, Katie?
Yes.
And Craig, quick question. You'd think that when I modified this to go from new to used, that would make a difference. But notice UCC says nothing about new, does it? It says simply tangible and movable. So would the UCC apply to the sale of a used car?
Yes.
Yes. So it applies to sell the computer because that's tangible and movable, and a new car and a used car. What are goods? Goods and services combined, what law governs? And the rule is, David is the predominant factor test. If goods, then the UCC governs. If services, an example, yes.
You frequently skip slides.
Oh, I'm sorry.
You double click.
Which one?
You don't
Click
have
it twice real fast.
I'm sorry, thank you. Goods associated with real estate, I did this because, thank you, I did this because of Katie, because she's a farm girl. Goods associated with real estate, contract to sell minerals or a structure is a good if severance is made by the seller. If severance by the buyer, the sale is governed by common law. And that makes sense. So therefore, in the case of Katie, a tree, I don't know why you would, why, I guess you would want, would you want to cut down a tree? Except you wouldn't call it a tree, you would call it timber. So I think that makes good. Sale of growing, what are goods? Goods and services combined. Michael, the example is, suppose I sell you 50 computers to be used in your business. And yet suppose that included within that is a service contract to train your employees how to use it, or any equipment. So the question is, Michael, is that a contract for the goods, or is that a contract for the service? And the answer is, it depends on the predominant factor. In that case, what do you think the predominant factor would be? Am I selling you,
Fine.
that is, does the training represent, does the training support the sale of the computers? Or do they sell the computers support the training? What do you really buy? The computers. Therefore, would the UCC apply? However, Kelsey came up with an example where the predominant purpose is the service contract and goods of nominal value are provided as part of that, the UCC would not apply. And of course, Michael and Kelsey, sometimes I'm going to argue, if I want out of the UCC, I'm going to argue it's primarily a service contract. If I want under the UCC, I'm going to argue it's predominantly a sales contract. What is a merchant? Article 2 imposes special standards upon a merchant whose special business expertise is not a casual buyer or seller. Linda, does that make sense? So I go to Michael's computer store and I buy a computer. Is it reasonable to assume that he knows more about it than I do? Well, of course, everybody knows more about computers than I do, as you well know. But I think, assuming that's a reasonable standard, that is, you have greater knowledge, greater expertise, or you should not be selling stuff. Cindy, who owns a bookstore, has a weekend garage sale selling used clothing to AJ and antique book to Cody. So, Sydney, are you a merchant and therefore held to a higher standard in the bookstore?
Yes.
Absolutely. What about the garage sale? What do you think, Kobe? As to the clothing? No, it's absolutely not. Linda, what about the antique books?
Probably.
Michael Newman.
Probably an expert, so.
But just think about this. Just suppose, Cindy, you don't want to be classified as a merchant because you don't want to be held to the higher standard. Then, do you focus on the word antique or the word book? Antique. Suppose, Linda, you're the customer and you want her to be a merchant because you want her to be bound by the higher standard, then you're going to focus on the word book. So the question is this an antique or is it a book? Also, Jody, would it also depend on what kind of books that she's selling in a bookstore? I mean, maybe, Jody, she specializes in antique books. That's clearly, well, let me think about this. Jody, if she is an expert in antique books, the fact that she's selling the books in the garage sale makes no difference. She's still an expert. You agree?
Yes.
So the question here is not whether it's, Linda, is not whether it's garage sale, but it's whether it's the type of merchandise she normally sells. And again, if you want out of the UCC, it's antique. But then, Alex, if she sells antique books, that's a losing argument. Open terms, indefiniteness is okay as long as the parties intended to make a contract. There's a reasonable basis. Now, Alex, compare that to the common law. For example, if I have a contract with you, you and I have an agreement to sell me X number of widgets. Oh, I'm sorry. You and I have a contract to sell widgets for $5 a piece, but the contract does not say how many widgets. Or the contract does not specify the date of delivery, or the contract does not specify the price. On common law, do we have a contract? No. Sydney, you agree? On common law, we do not have a contract. And Megan, that makes sense because the common law does not care. The common law is agnostic about the formation of contracts. Common law says if you have a contract, we will enforce it, but we don't want to encourage or discourage contracts. That is, whether the common law says we will enforce contracts that exist, but we don't care if you have a contract or not. The Uniform Commercial Code, though, Brandon, is designed to encourage commerce. Therefore, it follows then the UCC would be more liberal, more open-minded about the formation of contract. So notice the difference here. Brandon, indefiniteness is a killer under the common law, and it's okay in most cases under the UCC. Open price terms. Parties have not agreed on pricing, court could determine reasonable price at the time of delivery. But let's go back a minute. Indefiniteness is okay, Alex, as long as the parties intended to make a contract and there is a reasonable basis. Open terms. Unless otherwise agreed, or open price terms. Parties have not agreed on pricing, court can determine a reasonable price. So let me give you two scenarios. Scenario number one, Alex, is you and I have been doing business for 20 years, since you were 6 months old. And I've been selling you, I manufacture widgets and I sell them to you, and we've been doing this for 20 years. Can a third party reasonably determine what the price should be? Sure. Everybody agree? That is, the court can fill in the blank. However, let's suppose that I have perfected a brand new type of widget. It's a new and improved widget, and you and I have never dealt business before, and the price is not determined in the contract. Kobe, you got the story? Story number one, she and I have been doing business for 20 years since she was 6 months old, and the court can easily supply a number because we have an open price. Scenario number 2, it's a brand new product, and she and I have never done business before. In that case, Kobe, the lack of a price, would that kill the contract?
Yes,
How is that different?
because it's a new product that you can't compare.
And a third party cannot reasonably determine that. Okay. Open delivery terms, open payment terms, unless otherwise agreed, payment is due on delivery. Key word there is Alex, unless otherwise agreed. So therefore, Alex and I can say payment is due 30 days after, or we could say payment is due 5 days before delivery. But if we don't say, if we're silent, if we say nothing about it, UCC says payment is due on delivery. Payment terms, okay. Open delivery terms. Unless otherwise agreed, buyer takes delivery at the seller's place of business. And I think, Alex, in most cases, does that make sense? That is, if I sell you something, you come to my place and pick it up. Now, notice though, the key word here, Alex, is open. In other words, if the contract does not specify, that's the rule in the UCC, but we can specify otherwise. If no time or date is specified, court will impose a reasonable time. Open quantity. Generally, courts will not impose a quantity, there's no remedy. Now, one of the things that you'll see, Brandon, is sometimes, and I think I mentioned this before, sometimes the exception takes up more space than the general rule. So the general rule, courts will not impose a quantity and there is no remedy. So therefore, that means, Brandon, open price, if the court can reasonably provide a price, they will. Open delivery date, the court will provide, and so forth. But quantity, the court will not substitute. Does that make sense?
Yeah.
I think so. Exception as to quantity. A requirement contract is a buyer agrees to purchase what the buyer needs or requires. Taylor manufactures widgets, and Taylor agrees to supply all the raw materials that Taylor will need for the second quarter. So, Taylor, under the common law, do we have a contract? No. Why? Indeterminate. But then, Taylor, that doesn't matter because the common law does not apply because this is the sale of a good. So now, Taylor, under the general rule, under the UCC, so you agree on the common law we don't have a contract. Under the general rule of the UCC, we don't have a contract. But under the exception, do we have a contract?
Yes.
Yes.
Why not under common law?
Because it's indefinite. Under common law, you're going to have a definite, everything has to be spelled out under common law. So if anything, if any detail is missing, any material detail is missing, the common law will not supply. And that's, Michael, because the common law is agnostic about whether there's a contract or not. UCC is not agnostic because the UCC wants there to be a contract. Okay, so, output contract. Buyer agrees to buy all of seller's production output. Matt, retailer, agrees to buy all of Taylor's widgets produced during the second quarter. So, Matt, do we have a contract under common law? No, because it's indefinite. Do we have a contract under the general rule of the UCC? No. But do we have a contract under the exception? Yes. Okay. Merchant firm offer. Remind me, Kelsey, what the rule is if I say to you, I'll sell you my house, and you say to me, give me 3 days to think about it, and I say, okay, and then after I agree to give you 3 days to think about it, the next day I sell it to Sydney. Now that's,
You're allowed to do that.
arguably that's unethical and immoral,
Yes.
but that doesn't matter
It's not important.
because this is law. And the reason that I can do that is that you providing no consideration. Under UCC, we modify that rule, and here's the rule. An offer made by a merchant in a signed writing. So notice 3 conditions there, Alex. Number 1, it's got to be a merchant. It's got to be signed, and it's got to be in writing. It's irrevocable for a reasonable period of time. No consideration is necessary. And Kelsey, does that make sense that the common law would say, I can't do that, because the common law is agnostic about whether there's a contract? Does it make sense that the UCC, who wants to encourage commerce, would say that? By the way, does the UCC apply to the sale of my house? Does the UCC apply to the sale of my car?
Yes.
Method of delivery. Offeror can specify means of acceptance. Methods of acceptance. Offeror can specify means of acceptance. The UCC rule is modified so that any reasonable method of acceptance. Kelsey, remind me, the mailbox rule was that the acceptance is valid when dispatched,
Yeah.
even if I don't know about it. Under the UCC, the mailbox rule, which to me is a bad rule, because it puts the offeror in a bad position, is modified so that any reasonable means of acceptance circumstances permitted, and that seems to be more friendly to commerce. Additional terms. If one party is a merchant, contract is formed according to the original terms of the offer. Contracts with common law. Suppose if both parties are merchant, the contract incorporates the new terms. Unless original offer expressly limits terms, or there's a material change, or the offeror objects within a specified time period. So, A offers to sell a car for $50,000. Tellini replies, I will pay you $45,000. So Tellini, got the story?
Yeah.
She offers to sell you a car. You say, I'll pay you $45,000. Tellini, under the common law, what happens?
Rejects our offer and is counteroffer.
So you rejected her offer, made a counter offer, therefore we have no contract. Now, what is what is the result under UCC if you are a merchant and she's not? Then we have a contract for 50 or for 45? For 50. So the original term, so you're stuck to the 50. A offers to sell a car for $50,000. Tellini replies, I will pay you $45,000. What is the result, Tellini, if you're both merchants and Ann is silent?
There's a contract for 45.
For 45. So the last person wins. What if Ann, you object? Then we have no contract. So if you're silent, we have a contract for 45. If you object, we have no contract. Now, what happens to Tellini if you change the price to 5? Let me ask you, she wants 50, you offered 5. Tellini, is that a material change? Therefore, we have no contract. UCC versus common law. UCC adopts a common law rule requiring consideration. However, modifications to contract do not need consideration. So again, Kobe, I have a contract with you for you to paint my house. And maybe I should not have a service contract, maybe I should have a sales contract. I have a contract with you to sell you 500 widgets, delivery to your place of business in 5 days. That's the contract. You say to me, I would like for you to deliver the goods in 4 days. On the UCC, that's not a valid change because I need consideration. You agree? On the common law, that's not a valid change. On the UCC, we can change the contract without consideration. And again, Kelsey, that makes sense from the standpoint of the UCC is designed to encourage commerce. When modification without consideration does require writing, merchant and non-merchant contracts in which the merchant supplies the form. So this is the case, Toby, where you're the merchant and you're dealing with a non-merchant and you supply the order form. In that case, the modification has to be in writing. And that seems fair, Kelsey, to protect the non-merchant. Statute of frauds. All contracts for specially manufactured goods will be enforced. So Linda orders widgets from Taylor with Linda's logo on it. So let me make sure I understand this. Normally, under statute of frauds, Linda, a contract for the sale of goods more than $500 has to be in writing. The exception to that, if it's specially manufactured goods, it does not have to be in writing. So normally the contract has to be in writing. The exception to that, if it's for specially manufactured goods, it will be enforced. So Linda orders widgets orally from Taylor with Linda's logo on it. What would your logo say? Child. So my question here, Taylor, does this contract have to be in writing to be enforceable?
No.
The answer is no. Now, why? Well, one, that's what the law says, but why does the law say that? Let me ask you this. Could you sell that merchandise to somebody else with her logo on it?
No.
Probably not, or at a reduced price. And without the logo, you could sell it to somebody else. So again, Kelsey, does the rule make sense under the UCC? So what am I doing wrong, Mike? I'm sorry? We sort of should go blank. Okay, we'll do the last slide next time.